Welcome to Series Coin, everyone. I'm Kelly Willis Green. This is the podcast where we have rich conversations about wealth. Well, you've no doubt heard the Benjamin Franklin quote that nothing can be said to be certain except death and taxes. Well, taxes may be unpleasant to talk about, but death is downright uncomfortable. But we're going into the lion's den with this episode, folks. We're talking about estate plans, which you may think is scary or boring or both. But I hope you'll trust me, because making good decisions and having peace of mind around your estate plans is one of the most important things you can do for your family and your legacy. And I'm going along with you. My husband and I are in the process of updating our estate plans right now, and what I learn, I like to share. So in this episode, we're breaking it down with my guest, estates lawyer Michael Arlein. Michael is chair of the Trusts and Estates Group at New York City law firm Patterson Belknap. His practice is focused on tax and estate planning for high net worth individuals, and he works predominantly with founders and entrepreneurs, and financial professionals on Wall Street, VC firms, and hedge funds. In recent years, his clients have included some of the founders and principals at fast-growing companies like Slack, Casper, Roman Health, and Fubo TV, just to name a few. But tax and estate planning was not his first career. Michael took a slightly unconventional route to law, one that would ultimately serve him well as counsel to business-owning clients. And that's where we start our conversation.
After college, I did investment banking for 2 years. I was, 21 to 23 years old, and I was an analyst at a boutique investment bank. And it was really good training. I think it's training that most lawyers don't get, understanding the business world and learning how to use Excel and spreadsheets and running financial models. And it was really good background because a lot of what I do is tax planning, and there's a lot of numbers involved and projections and things like that.
Right.
So that was, 95 to 97. So it's kind of ancient history, but it served me well.
And relevant to your practice, I would think that your clients would have a certain level of comfort with you, having come from that business world and kind of like, this is a guy who gets me, this is a guy I can talk to about some pretty personal, intimate stuff.
I think that's right. And I'm also really good at working with people who have very little time, founders being the classic type of client who just barely has time to focus on their personal needs. So when they work with someone on that, they want someone who's super efficient, just, doesn't overcomplicate, cuts right to the chase, executes so they can move on to run their business.
Exactly. And so that's a good segue. Let's cut to the chase and get into estate planning. Talking about death is not something most people are comfortable with, right? And it's one reason people often put off getting their estates in order. I read a statistic where about half of Canadians have a will and only a third of Americans have a current will. So what is typically the impetus for your clients when they come in, they say, okay, we got to work on this stuff?
Well, the classic moment is when people, young couples, are about to have their first child. I think it's just sort of in the checklist of, oh, we're pregnant, we need to do our will. So I think it's really that focus on children and understanding, that you need to do some risk management. It's the adult thing to do to prepare those documents. That's usually the first moment. And then there's a lot of what I do is tax mitigation, and people really don't like paying taxes if it can be avoided. So I think people are very motivated. Often it's their accountant or their financial advisor who says, hey, you've got a problem here. We need to go to an expert who can help save taxes. So the focus is on saving taxes, not death or other unpleasant things.
Well, I don't know if you would consider choosing an executor an unpleasant thing, but it's an important thing. An executor is the person or people, you may have more than one, you can have co-executors, who oversee the administration of your estate according to the terms set out in your will. Michael described it to me as the CEO of a person's estate. And although it's a short-term role, depending on the complexity, it can last a couple of years and involve a lot of time. Michael had this to say about the qualities you should look for when choosing your executors.
So I think a lot of the qualities that you would find in a business CEO are good qualities. So, someone who is in the professional world in some capacity. The executor doesn't need to be a lawyer, but someone who works in the business world, who's used to dealing with lawyers and accountants. My joke I tell is sometimes like, don't name your cousin who lives in the woods and who's an artist who just
Right.
doesn't deal with in the professional world. Obviously, good judgment, I think, is important. Someone who's decisive but thoughtful, someone who's diplomatic, obviously ethical and honest is important. An appropriate age, right? You don't want to name someone older than you as the executor, or even your contemporary necessarily, because they might not be around to fulfill the duties. One mistake that people sometimes make is assuming that there's a exact parallel between being really good in business and being a good executor. And there's a lot of overlap, but it's not exactly the same. What we don't generally want in an executor is sort of a wheeler dealer type person, someone who's used to just kind of getting things done really quickly. We want someone who's more deliberate and cautious, I think, as an executor, because being a fiduciary, which is what an executor is different than being in business. Being a fiduciary is a more conservative, cautious thing, where you're trying to preserve and make, very conservative decisions.
And just for people who are listening, maybe don't know, a fiduciary means that you are legally required to act in the best interests of the person you're representing. Is that a fair?
That's correct. You have a duty of care, to act prudently, and you have a duty of loyalty to avoid self-dealing. And I think that's an important point, that don't just pick, your brother who's a high-flying investment banker as your executor because you assume, oh, he's, really good at business and therefore to be a good executor. Sometimes that's not always the case.
Yeah. And one thing that we see a lot is people picking their spouse either by design or default. Certainly someone they trust. What would be some good reasons and some not so good reasons?
It is a common choice, and I don't try and talk people out of doing that. I think it's my default assumption is that your spouse will be your executor. And I think that that's fine. At the first death, often not a lot is happening. There's, most often we design estate plans where there wouldn't be any tax to pay. You're not selling homes and liquidating things. There's not much change happening in the estate. This is a generalization. Obviously, there are sometimes like a second marriage, and that's the place where I'd be careful about just naming your spouse. But I think unless your spouse is going to be completely overwhelmed and says, I don't want to do this, please name someone else, or please name your brother along with me. Most of the time, I think the spouse wants to be the executor, gives them a sense of control. And a lot of what the executor has to do can be delegated to professionals, the legal and accounting team. So the spouse really just needs to have some common sense to oversee those people.
The other thing that seems to be becoming real for us, we've had 2 deaths in our family in the last 6 months, and where the spouse is older, it's one thing when you're 40, 50, but when you're 85, 80,
Yeah.
it's a much more challenging role and may not make sense, but it's hard to change at that point as well. The spouse may see it as an affront.
I think that's right. I mean, your estate docs are a living thing. They have to be updated over time. And I definitely see, for sure, for people that live to that age, there often comes a moment when the children are more involved and they say, Dad really shouldn't be naming mom as the executor anymore. She's just not capable of doing it. So we'll make a change and have the children come in as the executor at that point.
I'm glad you mentioned children, because one of the things that I hear from people as well is difficulty choosing sometimes between their children, and they feel like they might be favoring one if they choose that child as the executor, or maybe one has a much more dominant personality and would run roughshod over the other if they were appointed joint. So it's a bit tricky as well. How do you look at that and what do you advise clients?
It is very tricky. I think it's important if the children are going to all be beneficiaries of the estate. Sort of the default assumption is that it would be a good idea for them all to have a seat at the table, and that you could, if you name your child who is the more dominant person in the executor role, that could have a negative impact on the relationship between the children, because the person who is left out as an executor might become suspicious or just feel hurt that they were excluded.
The irony, though, is it's no gift. It's kind of a burden to be named executor. So,
It is.
I mean, it's part of the job just to explain to the kids, look, this person's going to do it because it makes the most sense from a professional point of view, but
Yeah,
they're all equal beneficiaries.
I think that's right. One mistake that I think we see is that if your children don't get along and you appoint them, it's a disaster. We have had many situations where the parents said, "Oh, we need to name both of our children because we want them both to be included." And the children just simply don't get along. And often the knives come out after the parents are deceased. And there's a lot of things to fight about. For example, dividing up physical belongings is often, very fraught. So if you have two people who don't get along, we've seen them both lawyer up, and then every single decision becomes utterly painful. And sometimes the parents say, "Oh, we have a great idea. Let's name a tiebreaker. We'll put our lawyer as the third executor. And if these two don't get along, what ends up happening there is that person just becomes a punching bag. And the two children who don't get along are lobbying that tiebreaker and driving them crazy. And it doesn't work. It's not a good solution. I think you should just not name the children at all in that situation, or you should pick one. Although if you pick one, the other one, there might be a lawsuit. The other one might end up accusing the one who is the executor of doing bad things. So that's not great either. It's sort of a no-win situation, actually.
If you pick one, and when it comes to, art and, personal belongings, if you make your wishes very clear in advance, and the executor's following the directives, is that a solution?
Yes. I mean, I guess if you literally allocate every single thing you own and say these things go to this person and these things go to the other person, but no one ever really does that.
No.
And you would be shocked at what people fight about. It's not always mom's diamond ring. Sometimes it's, a family photograph or a piece of art that mom did when she was 20 years old, or something meaningless to anyone else.
With not a lot of value.
Right. Not a lot of material value. Exactly.
So then I want to bring in the idea of an institutional executor, a trust company.
Yeah.
And in fact, that's something that my husband and I have been looking at as support for our named executors. What are the pros and cons of an institutional executor? Is it a popular choice? Where do you stand on that?
So I think that the pros of an institutional executor would be they have no emotion. They're professional. They do this for a living. They have a deep bench they have people who are sitting there who just all day long are administering estates. The frailties of human nature don't apply, right? If you
Right.
name an individual, they can get old, they can get sick, they can get distracted, they can develop a drinking problem, all sorts of bad things can happen, but that's not going to happen with an institution. The cons typically are that it costs a lot of money. It may be that your children would do it for free because they're the beneficiaries of the estate, or even your family friend or your brother wouldn't charge a full executor's fee. It can cost hundreds of thousands, even millions of dollars for a very large estate to have a professional. I think the other knock on professionals is that they're impersonal, right? They don't know your family. They may not know the nuances of your business or your assets. They just kind of come in and try and do the best job that they can. Sometimes people name both, a professional paired along with a family member. And I think that may be the best of both worlds, because then you get the personal touch, but the professional can be delegated a lot of the grunt work.
That's what we're looking at doing. And I think the professional would work under the direction of a friend.
Yes.
But you raise a good question in terms of a friend or a family member would be more personal, but really, most people don't know what's on somebody's balance sheet. And your clients have complex balance sheets. There's probably, at one point in their lives, there's multiple homes, and there's probably art collections in those homes and collectibles and many, many illiquid investments. So it's a lot to ask somebody to execute on. And I think that would point to institutional choices. Just thinking, from my own, I wouldn't want to burden somebody with that, but I would like somebody representing me and how I think and feel about things and might behave around things. How do you advise your clients to make it easier for their executors, or can they?
Yes. Well, I agree with what you just said. And I think for large, complicated estates, you're almost forced to go professional, because no one really, it would be a full-time job for someone to administer the estate. It's a lot to ask. If you don't go professional, because the estate is not complicated, right? Large doesn't necessarily have to be complicated.
Correct.
You could have a very simple estate that's just, where you've got $100 million in Vanguard funds. That's a simple estate.
Right.
Or you could have a small estate that's complicated.
Right.
But what I always tell my clients is, we go through a thought exercise where I say, imagine you and your spouse are run over by a bus. I literally say that. You got to use some humor here in these discussions. And your executor walks in the door and says, what on earth did these people own? Who were their advisors? What is the password to the laptop? What is the seed phrase to get the Bitcoin off the hard drive? And then I encourage them to spend some time organizing all that stuff, to create some sort of file. Maybe it's a spreadsheet or a list, where they just kind of think about every possible thing that would make the executor's job easier. And I encourage them maybe once a year to update that list. Mm-hmm. And then that's a very sensitive piece of paper that you wouldn't want to fall into the wrong hands. So I don't take that list, but I ask them to give me the treasure map. I ask them to, in a sealed envelope, to give me the instructions as to where the executor can find that list. It's a note. It says, we've made a list for you. You can find it on Joe's laptop. Here's the password. It's in this folder, and it'll make your life a lot easier.
I think that's a great idea, and I'm going to suggest to my husband that we implement it. In fact, it reminds me of something a former mentor of mine used to do. Whenever he and his wife traveled, he would place a sealed envelope on his desk in his home office. It contained directives for his daughters about who to call for what in the event that something happened to him and his wife while they were away. It was all on one page, he'd say. And he used to tell me, if it's more than one page, your life's too complicated. But in terms of preparing your executors, I wanted to know from Michael how much you should bring them inside the tent and when.
Going back to something you said before, I think the older people get, the more real this becomes, mm-hmm. and the more seriously they take it. So if I'm working with someone who's 35 years old and they're naming their executors, they're not probably going to spend a lot of time bringing their executors up to speed on their assets and what the job would entail.
Death feels almost theoretical at that age, right?
Absolutely. And I think even much older than that, when people say reach their late 70s, maybe 80s, they start to take the estate planning process a lot. And I think that's the moment when you might bring the executor in to make sure that they have a full understanding of what the job's going to entail.
I think another impetus, speaking personally, is if you've been an executor, you understand the importance of that role and the amount of time that's involved. And so you think, well, how could I simplify this for someone else? Or how do I make sure someone else is prepared? Or if you, as I said, have had a death and had a front row seat to someone else grappling with the challenges of dealing with an estate. At least that's been for us, an impetus to get better organized and realize that we don't want to be a problem for others.
I think that's right. One type of executor we haven't covered yet was sort of the human being professional executor. So not a bank or a trust company, but a lawyer or an accountant, right? That's another very common choice.
Yes.
I think that you have some pros and cons there. You still have the frailties of human nature, right? Your accountant is going to get old, might get dementia, might be going through a divorce and is really distracted. But on the positive side, these people are repeat players who have administered many estates and learned the lessons and would be able to do it more effectively and efficiently.
I think that's a great idea.
So I think that's a pretty common choice.
It does bring the subject of compensation to mind because presumably you're compensating those people. How often is it that executors are compensated?
That's a really good question. I think if it's a professional executor, they're obviously going to get compensated. For banks and trust companies, they have a standard fee schedule. I think it's negotiable if you have a very large estate. And it's something, if you're going to hire one of those, that you should look into. You should enter into a fee agreement and maybe seek to negotiate with them off their rack rates. I think if you're working with a lawyer and accountant, the lawyer or accountant might also often be willing to enter into an agreement because the law firm or the accounting firm would likely be doing professional work for the estate and getting compensated for that. So maybe the lawyer or accountant, who's the fiduciary, would be willing to take a reduced fee because their firm is also making money on the estate. I think if you're going to have a family member do it, I think often if the family member is also a beneficiary, then they don't take compensation.
Right.
Because they're basically being compensated because they're a beneficiary. I think if it's a family member or friend who's not a beneficiary, like you name your nephew to administer the estate, then I would encourage clients to offer compensation for the reason you mentioned. It's a ton of work.
Yeah.
And it's a thankless job. And so I think it's kind of inappropriate to assume your nephew will just do it because he or she is your nephew.
Yeah.
And so when I say that to clients, they often say, I get it. We should provide maybe not a percentage of the estate, but we're going to say that this nephew is going to get $150,000.
Let's switch gears now and talk about powers of attorney, particularly healthcare, if we could start there. And again, I'd like you to define that role because I think a lot of people have the misperception that it means you have to take care of somebody.
Yes. So a healthcare proxy, as it's known, is a standard estate planning document. It's a document that allows you to appoint someone to make medical decisions on your behalf if you're incapable of making those decisions. It's the pull the plug person. But it's also not necessarily the pull the plug person. It doesn't have to be for end of life care. It could just be that you're temporarily incapacitated or going under anesthesia, and it's possible something comes up and the doctor needs to take instructions from someone.
Or you're incapacitated through dementia.
Right. Exactly. Any situation where you're incapable of making medical decisions for yourself, this allows you to name a person to do it for you. And most often people name their spouse, followed by a child, if the children are old enough. And if not, I typically would see a parent or sibling.
And powers of attorney for property.
Also, another standard document that every person should be doing as part of their estate planning. It's called a durable power of attorney because it survives your incapacity. And in fact, it's intended to be used for your, when you're incapacitated. And that's the same situation. You have dementia, you're in a coma, and someone needs to make financial decisions on your behalf. There are two different versions of that. One is called a springing power of attorney, and that's where there's a trigger. For example, in the document, it says this power of attorney only comes into effect if two doctors, including my primary physician, certify that I'm incapable of managing my financial affairs. And then there's a regular power of attorney where as soon as you sign it, those individuals, should they possess the document, would have those powers. You would think that the springing power is really what most people want and what's intended, but we actually talk most people out of a springing power for the following reason. It's very difficult in practice to get a doctor, unless you're really far gone, like vegetative. It's really hard to get a doctor to sign something saying this person is incapable of managing their financial affairs. Why? Because if by signing that, the person then gets power over your assets and messes something up, guess who's going to get sued? The
Mm-hmm.
doctor. So that's a tricky one.
Michael's point about when the power of attorney takes effect is an important one and should not be overlooked. In fact, as a result of this conversation, my husband and I quickly reviewed the drafts of our POAs, and guess what? Unbeknownst to us, mine says the power of attorney takes effect immediately, and his is drafted as a springing power of attorney, where incapacity would need to be proven. We aren't even sure where this instruction came from, but we're making changes as a result. So I urge listeners to take a look, read the fine print, and make sure your wishes, whatever they may be, are accurately reflected in the document. And since most of us like to know what other people are thinking and doing, I asked Michael to name the top 2 or 3 concerns his wealthy clients have in planning their estates.
I work with a lot of people with young children. As you know, I work with a lot of founders and of tech companies who tend to be often younger people who have children who are minors. I think they're trying to make decisions without almost any knowledge about how their children are going to come out. And so I'm asking them things like, if you and your spouse are both deceased, at what age should your children, gain access to money or gain control over money? And they just don't know. If you're unfortunate and you and your spouse die before your children are grown up, then whatever decisions you made, you're stuck with. But hopefully over time, you'll see how your children grow up and you'll be able to tweak the documents. But people worry about that. They take this very seriously, and they're sitting with me and I'm asking them questions about their children, and we don't know. Our children are 2 and 4 years old. We don't know what decisions to make. So I think that's a tough one. I think the topic of today's conversation is also difficult for people who to name in various roles.
Mm-hmm.
In addition to the ones we've covered today, the executor, the healthcare agent, and the power of attorney, you've also got 2 really important personnel decisions in the guardian for young children and the trustee for young children. Guardian really takes physical custody of young children and sort of becomes their parent. And then the trustee deals with the money. And so people are concerned about choosing the right family members. Should the guardian and the trustee be the same person? If the guardian's making decisions around where the child should go to school or certain other things that cost money, if they don't have the purse strings, they have to go to the trustee and ask for the money to pay for those things. Is that a point of conflict, or is that a good thing to have checks and balances, to have 2 people in that terrible situation who both have a legal role with respect to your children and who would have to work together and hopefully come to a good decision?
And you mentioned having the chance to update this. You sometimes hear people should take a look at or review their wills and estate plans every 3 to 5 years, right? Things change. You buy new properties, you sell things, you have another child or what have you. And then as you age, again, I think that's a different life stage as well. Not that, hopefully I've got a lot more years left. It's just a lot easier when it feels theoretical and when you're healthy. I know when my late husband was ill with cancer, he was updating his will. And that's a lot less comfortable conversation.
Yeah. I think I deal with people, and people, there are different kinds of people, right? There are planners and procrastinators. And the same people who procrastinate on other decisions often procrastinate on their estate planning and wait until the very last minute, and then it's really sort of stressful. And I've done a lot of deathbed planning for people. And then there are planners who, when they're 35 years old, are doing everything. They're really thinking through everything and just kind of checking off those boxes. So we can accommodate both kinds of people, and we have to accommodate both kinds of people in my practice. I tend to be a planner, so I jive well with that sort of person. And it makes me anxious when someone comes in and they're 86 years old, and we talk about their will for a year, and they keep tweaking it, and they just won't sign it. And I get nervous, and I encourage them to just sign the will. Let's not let perfect be the enemy of good. You can always update it in another couple months. But I think there's a psychological barrier for certain people. They feel like when they sign the will, maybe they're going to, at that point, die. I don't know.
Well, I'm definitely a planner then. I got very inspired and wrote down my death wishes, my celebration of life, who I want to have speak, the music, the readings, the theme. No one who knows me will find this surprising at all, but I actually found it quite liberating. So there you
Yeah.
go. Michael, this has been great. Thanks for being generous with your knowledge and your expertise around this. I'm certainly walking away from this one fired up to get my estate plan update done. And I have more conviction in my choices thanks to you. And I hope that our listeners do as well. But before I let you go, there's just that final segment where we have our lightning round of quick top of mind answers to some money questions that just give us a little more insight into you and how you see things.
Oh, gosh.
So what's the best free thing that money can't buy?
The best free thing that money can't buy? Oh, gosh. Happiness.
What is one thing most people are surprised to learn about having wealth?
That it's a lot of work.
Mm-hmm. What's something most people would say you spend an inordinate amount of money on?
I'm an avid gardener, so my wife is always surprised at how much money I spend on plants.
It's funny, I had somebody else say gardening equipment, so there must be a theme here. What's something you underspend on?
Clothing.
Lastly, if you could finish the sentence, to me, money is...
To me, money is being able to do what you want in life.
I want to thank my guest, Michael Arlein, for helping us tackle this sometimes uncomfortable but universally important topic. And I hope it has empowered our listeners to make thoughtful decisions about their legacies. Remember, preparation is key, and a well-informed choice can make all the difference in preserving and protecting what you've built. If you'd like to get in touch with Michael Arlein at Patterson Belknap in New York, you can find his details on the firm's website at pbwt.com, and I've put a link in the show notes. Thanks for listening to Serious Coin. We have more rich conversations coming to you this season, so I invite you to subscribe and please give us a 5-star rating so other people who are curious about living better with wealth can find us. Serious Coin is provided for your general interest only, and nothing we discuss should be taken as investment, tax, legal, or other professional advice. Always talk to a licensed professional before you make any financial, legal, or investment decisions.